Any mention?
May I please, Your Lordship, I beg to mention item number 14 from the main cause list.
Yes.
I pray for 2 weeks' time, Your Lordship, as the senior conducting counsel is it's not well today.
No objection, Your Lordship.
Tweaks on the request made on behalf of the petition. Yes.
Much
I'll
obliged,
oblige.
Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 16, Your Lordship.
Yes.
Your Lordship, since the issue on consent is being heard today in the Supreme Court, Your Lordship, so I pray this matter may be fixed after 4 weeks.
We'll have it after 3 weeks.
All right. Highly obliged, Your Lordship.
That is quashing of a
Quashing
POXO
of
matter.
POXO
matter.
proceeding, Your Lordship, yes. Item 16.
Yes, on the request to the Land Council of the petitioner, least after 3 weeks.
Highly obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 11, 12, and 13, Your Lordship. This is a connected matter, Your Lordship. 11, 12, and 13. Your Lordship, I pray, Your Lordship, that the matter may be listed after 3 weeks, Your Lordship.
Why?
Your Lordship, the conducting counsel is having some personal difficulty, Your Lordship.
Yes, Mr. Sinkan,
My lord, I'm there.
you are appearing for the state.
12 and 13, yes, my lord.
How are you?
11.
Mr. Kharmi is also.
Please, Mr. Sinkan.
So you have no objection.
No, my
Okay, 11, 12, 13 also. Just 3 weeks on the request on behalf of the petitioner.
Highly obliged, Your Lordship.
You can write it, arrange it properly.
My lord, item number 7, my lord, if it can come up after 2 weeks, my lord.
Petition number 7.
Yes, my lord. Hearing list.
This is a 2018 matter, Mr.
My lord, by next date, my lord, we can dispose this case.
This was service matter.
Yes, service matter, my lord.
The other side?
KP Bhattacharya.
So now how to know whether what is there? Any
My lord,
it appears to be a miscellaneous application also filed by the state. That what is that?
that was long back, my lord, because there wasn't stay order, and then that
This is an application for vacating the stay.
yes, but that was never
allowed.
considered. That was never considered, my lord.
That was not pressed or not taken up.
Yes, ma'am.
So what is to be done? How do you know whether state what will be the whether state will have any objection or not?
Let it come up, my lord, on the next date, my lord. We can dispose this
No,
cases. my
that
lord.
is okay. But then for today's prayer,
He has not come, Lordship, Mr.
he is
KP.
not-
Let
this
it
is
come on the
problem.
next date.
He is can wait for sometimes just
My lord.
let the matter be called and we'll just
Yes, ma'am. All right.
Your Lordship, I beg to mention item number 4. Your Lordship, similar matters pending before division bench.
there is a matter which you say is connected to matter
Yes,
pending
Your
before
Lordship.
division bench.
ROW.
This is correct.
Yes, Lordship.
Nakma ship.
Your Lordship?
Nakma land acquisition matter.
Yes, Your Lordship.
When this division matter is likely to be taken up? When this
This month, Your Lordship, May 7th, likely. Not 17th of May, if I'm not mistaken, Your Lordship.
okay. The request to the petitioner release this matter after 3 weeks.
3 weeks, Your Lordship.
Yes.
Obliged.
Obliged.
May it please Your Lordship. Your Lordship, I beg to make a mention of item number 10, Your Lordship. Your Lordship, I pray if this matter may come up after 2 weeks, Your Lordship.
Yes.
I'm for 123, my lord.
I'm for 4, my lord.
You have no objection.
No option.
When do you want it?
After 2 weeks, Your Lordship.
Then also. So on the request made in business. Yes.
Much obliged, Lordship.
Supplementary causes, item number 1.
Yes, Mr. Khan.
Both were disposed of, Your Lordship, no pending memoranda pending.
But then concurrent finding in a Jimma matter.
Lordship, yes. Both were applications, so there's no list pending before the trial court on that issue. They file a separate application
Yes.
for Zimma.
But then there is no other remedy except for 482.
No, Lordship, we have checked it because Lordship will just take your Lordship first to page 36, just to give the brief fact of the case.
Page 36.
36.
Yes.
So this is the wildlife offence report. Name of the Lordship, the relevant part would be 6, but I'll just say name of the forage range. The forage range in which the vehicle and the wildlife was seized was Nongpo Wildlife Range, Nongpo under East Khasias. So location is very important, Your Lordship. It's in the Nongpo Wildlife Range. Lordship will come to 6, nature of offence and section of law.
Yes.
Position of 2 white crown hornbill. 4 number of bushy crested hornbill, where 2 were dead and 1 was red and blue lorry. So these two, Lordship, number 6 is very crucial. I'll come to it why this is very important. And Lordship will come to 13, clause 13, description of the incidents or offence reported.
Yes.
On 3rd September, a call was received from Divisional Forest Officer East Khasi's Wildlife Division, Shillong. The police from Umroi has apprehended 2 persons with a possession of wildlife. As it was already late at night, a request to the officer in charge, Umroi, PIC, as can be help seeking keeping both accused and the wildlife, and that the next day the office of the Forage Range Officer, Nongpo Wildlife Range, will come and take over the accused and the wildlife. Today, the 4th September 2023, the undersigned along with staff went and took both the accused and the wildlife from so-and-so and brought them to Nongpo Wildlife Range for further necessary action. The accused was seized with the possession of 7 individuals of birds, out of which 6 were hornbill, 2 dead, 4 alive, and 1 red and blue lorry, cash of rupees so-and-so, 1 black color leather wallet, 1 Redmi 9A touch screen mobile, 1 Redmi.
Where you are reading that?
Sorry, last part, Your Lordship, page 36.
Yeah, page 36, last word is 1 Realme.
Yes, Lordship.
Then
Realme. So
it seems it is not complete.
Lordship, yes, sorry, apology, Lordship, this was not complete. But we just had the Caesar copy of this only. So Lordship, be that is at me, the most important issue is that the Caesar of.
If one page of the report is missing,
Lordship will come back to it subsequently because the subject matter is the hornbill and the
then
disease.
we should have complete document.
Apology, Lordship. It should have been there.
We can overlook it, but then you see like
Lordship is correct. This should not be incomplete. Because suddenly we should not go blank. After that, what? I'll just come back to it subsequently. It's not the issue of overlooking, Lordship, but yes, Lordship is very correct. But the subject matter is, Lordship.
See, until unless record is complete, we can understand it may not be very important. But then
Lordship is correct. I apologize, Lordship. Lordship is correct, absolutely.
You correct it, let it come up tomorrow.
ठीक है, Lordship is correct.
You do not have a copy.
He's checking the original. So we'll correct it, Lordship. Lordship is correct.
It appears that certain documents appended with the petition is not complete. Just say it appears that certain part of the documents appended in the writ petition are missing. This is the only thing missing, or there is any other thing?
No, only this. The last page is missing, Lordship.
Even then you check it, at least there should not be any disruption when this matter is taken up.
No, absolutely. We'll check it out.
Those are missing. Mr. Khan Learned Age praised that matter, praise for passing over the matter, so that the missing document can be appended. Delete petition. Prayer alert list tomorrow, day after tomorrow. All right.
Tomorrow is Friday, yes.
Prayer alert list tomorrow. Who this normally for offences under the Wildlife Act, who prosecutes? Who takes up the investigation?
Normally, Lordship, the complaint has to be made by the forest officer, and police takes it.
Here, this is a case. Who is the petitioner?
Here, Lordship, the who's filed
The State of Meghalaya through the Secretary of Forest Department.
Lordship, yes.
Was he a party before the court below?
Secretary was not the party, Lordship, yes.
Where is the order? Where is the impugned order?
Impugned order is the Lordship 23.
Is the appellant?
Lordship, yes. Appellant is the forest, Lordship.
Okay.
Daily costless, item number 1.
May it please your lordship. Lordship, I pray for further 2 weeks' time, your lordship, in order to file the affidavit in opposition, your lordship.
It's pending for quite some time, so filing an affidavit
yes,
on
your-
behalf of.
Yes, your lordship. I beg an apology for that, your lordship.
Yes, madam. Any objection?
No,
objection.
Lordship, another chance may be given.
Okay. Miss, just write her name, so and so. Reason allowed further 2 weeks time for filing an affidavit. For filing a counter affidavit on behalf of the respondent number 9 to 11.
Much obliged, lordship.
Item number 3.
Reason allowed further 2 weeks time. Yes.
Please, Lordship. Lordship, we haven't received the death certificate, Your Lordship.
Given
We
enough
have
time.
tried a level best, Your Lordship,
We have,
but
so
still fail to get
so-
contacts with the petitioner, Your Lordship.
we'll close the matter then.
Lordship, respondent 2, 3, and 4 are still there. Petitioner 2, 3, and 4 are still there, Your Lordship.
So okay, then we'll hear him. This what, Nakma?
Nakama, Your Lordship.
Because see, you have been given time since when? Quite some, it is until now you have not been able to manage. And I don't think that there is any likelihood that you will be getting a copy of the certificate. So, what would be the consequence? Can you represent this person who is already dead?
No, Your Lordship.
So then, this petition will stand dismissed so far as he is concerned.
Lordship, petitioner 2, 3 and 4 are still there, Your Lordship.
No, that is okay, but then so far as the number 1 is concerned, this writ petition will stand dismissed as against him.
Lordship, he may be struck off from the area of petitioner, Your Lordship. Petitioner number 1 may be straight off from the area of petitioner, Your Lordship.
Could not follow, this court could not follow.
Petitioner number 1 may be straight off from the area of petitioner, Your
No,
Lordship.
but on what basis? On your submission. If you want that, we can do it, but then that you will bear the risks. Give us the date of death, and then it should be in writing. Then you file a petition in your capacity. We will do that.
Lordship, may fix the matter next week, Your Lordship.
So we'll just say you are making a prayer for striking off, and you will file an application for that.
Yes, Lordship.
Is that all right, Mr. S. Millingap? London Council, let me for the petitioner submits that an application submits that in spite of best of vote, a copy of the certificate of the petitioner number 1 could not be obtained by him. He submits that an application for striking off the name of the petition number 1 from the area of the parties, from the area of writ petitioners, would be filed by him. Or rather, just say he submits that he intends to file an application. Mr. So-and-so, London Council for the petitioner submits that he intends to file an application for striking out the name of the petitioner number 1 from the array of the parties, and for that requires such time. Chalo, then give a full stop. Say in view of the submission, release this matter after
2 weeks, Your Lordship.
2 weeks. In the meanwhile, the Land Council shall take appropriate steps for filing an application for striking of the name of the writ petition number 1.
Item number 6.
If there is repetition, then last line you do not give. Okay. No one is there for the petitioner. What is this matter? This is service matter.
Yes, Lordship. Lordship, this is where the petitioner had applied for tradesman cook, Your Lordship.
Oh, that cook matter.
Yes, Lordship.
Chicken curry.
Yes, Lordship. If I may draw Your Lordship attention to order dated 19/3/2024, Your Lordship.
19/3/2024,
Your Lordship. Lordship, we were supposed to seek an instructions, if I may take Your Lordship, to
Yes.
page number 2, Your Lordship. last para.
Yes.
Learned counsel appearing for the respondent submitted that the petitioner was not found fit in the treat test, and this court cannot going into the matter in which the test was conducted unless there is a malified or prejudice is shown, and in the absence of the same, the petitioner has no right to ask this court to interfere in the selection process. Learned counsel further submitted that he will obtain instructions as to whether other candidates who are being selected and appointed have participated in the written examination, and after declaration of the result, a test was conducted on the same day or not, Your Lordship. Your Lordship is still awaiting instruction from the department, Your Lordship, pertaining to this, Your Lordship.
Who are being selected means they are not yet selected, or they are selected already.
They are already selected, Your Lordship.
So why you say who are being selected?
Because, Your Lordship,
That means saying the meaning thereby that process is on.
because, Your Lordship,
Achha. Okay. It's a language problem. It means.
yes, Your Lordship.
Now, you see, that we understand, but then is there, I don't think in this case there remains any doubt that the test for the petitioner was held on a separate date.
Yes, Your Lordship.
Yes. Say supposing if you get an instruction that all other candidates' tests were conducted on the same day,
Yes, Your Lordship.
and the petitioner test was conducted on a different date,
Yes.
what difference it will have, or what bearing it will have in the matter? See, this is a case, so far as this court recollects, I think the petitioner, due to certain reason,
Yes, Your Lordship.
was not allowed to take part on the date fix, on the date fix.
Yes, Your Lordship, because of his bogus domicile.
But then subsequently on his representation he was allowed.
Yes, Your Lordship.
And then different date was fixed and the test was conducted,
Yes, Your Lordship.
wherein he did not qualify.
Yes, Your Lordship.
That is the case. So I don't think you need any fresh instruction with regard to this. What you will do with this? We do not know.
A little clarification may be required, Your Lordship.
Anyway, none appears for the petitioner. Miss LMD Sangma. No, you are Miss
K. Gurum. K. Gurum.
T Guru.
K.
K Guru. Sorry, this court is very poor in remembering names. What is it? None appears for the censor. Learned counsel appearing on behalf of the respondents submit that she is yet to receive any instruction. As required by this court's order dated 19/3/2024 from the respondents, and prays for grant of some more time. Prayer allowed. List after 2 weeks.
3 weeks, Your Lordship.
3 weeks. Why so long? List after 3 weeks. This is 2017 matter. And if you say he doesn't have a case, then you finish it. 3 weeks for this thing. No, we'll have 2 weeks. List after 2 weeks. 3 weeks is too long for this.
Much obliged, Your Lordship.
Item number 7.
This is the matter, my lord, I was praying after 2 weeks. My lord. Mr.
Yes.
KP.
Not session, Lordship.
You are ready for the adjournment.
Lordship, my colleague is in Zone Legs before the division bench, Lordship.
You are not arguing this matter.
No, Lordship. Miss Ailingwa and Mr. KP Varshaja handling this matter, Lordship.
Just say, Mr. and Singhon Learned Counsel in view of the petitioner. Please for adjournment of the matter. On what ground?
We can do the hearing on the any date, my lord, even after 1 week.
Today's adjournment is, you are seeking adjournment on what ground?
Today, my lord, I'm not ready with the case. In fact, my lord, this matter was already heard before.
Mr. Non-Counsel was the petitioner, please, sir. Adjournment of the matter by 2 weeks. So, Mr. H. Kharwanlang, Learned Senior GA appearing for the respondent has no objection.
Additional.
Oh, additional senior GA.
My apologies, Lord.
There's no objection. Prayer, Lord. Obliged. List after 2 weeks.
Obliged, Lordship.
Item number 8.
My lord, this is a matter,
Yes.
earlier occasion, so lordship has heard the matter at length. And before concluding, roster was changed. The matter travelled to courtroom number 1. Now lordship has returned back to my lord bench. I will try to precisely address the issue and place few judgments. Is with regard to removal of the petitioner from the
Just give
post.
an outline of the case. What is the matter about?
This with regard to the appointment of the SSA teacher. SSA teacher under the SSA scheme. Now all the appointments under the SSA are contractual in nature. Now earlier in this particular school, 3 teachers were there.
Contractual in nature because it is
Under the
it
scheme.
comes with some specific period of time or something like that. Is
Yes,
it?
yes. Under the scheme, flagship scheme of the SSA.
No, that scheme means like then if you say contractual matter, that means after each and every appointment, you have to execute one agreement.
Yes,
Or it-
contract agreement.
Okay. So then the teacher and the appointing authority.
Yes. Managing committee used to appoint and the STSUO give the approval. And service started from there. And
No,
they
but
were-
then what about the contract? Who decides the contractual, the terms and conditions of the contract?
but it is the managing committee appoint and the government needs to approve. So that is the system.
The terms and condition, you say appointment are essentially contractual. So it means there is a contract, there are terms, isn't it? If you say appointment is contractual, that contract has to be by virtue of certain rule or by an express agreement, isn't it?
In fact, there is no express agreement entered between the employees and the employer here. It is a normal appointment, but the appointment is not that full-fledged because it is a
It means
recognized.
the appointment comes with certain conditions.
Yes, it is aided school. It's an aided school.
So whether these conditions are provided in the appointment letter
It is
itself,
not provided there. It is not provided there.
it is
but
not
admittedly,
provided. Then what basis you say it is contractual?
my lord, here the service is under the scheme. Once the scheme is withdrawn,
Yes.
my lord, the service condition of the employees will be changed. Because under the scheme,
But that is
they
okay.
derive some benefits.
It means you can say that so long the scheme is in operation, the service also would carry on. Once scheme lapses,
Yes.
then
Service condition is
service
changed.
automatically terminated.
Service condition, either they will terminate
Now
it.
this SSS scheme is for how many years?
No, in fact, it is not a
Sit down, ministers.
SSS came into being after insertion of Article 21A of the Constitution of India, and that is in 2002. Now, after this amendment was made, now it was provided in the Constitution that every state shall have the obligation to provide free and compulsory education to all children at the age of
After
6
the
to
right to
14 years.
education act was introduced.
Yes, yes.
Yes.
Now, to implement this constitutional amendment, the government of India introduced this scheme, SSC, Silva 6 RPN scheme, that empowers the state government to implement this constitutional objective. Now, they grant the financial grants also extended to all the schools. And under that schemes, the employees, maybe in the service or yet to be in service, give the appointment and they extend grant to all the schools. and the school received this one and implement this scheme. Now here the petitioner.
The scheme, so far as the present existing scheme is concerned, it has no period specified there. The
Yes.
scheme will be for 5 years or 3 years or something, nothing like that.
My lord. Suppose, my lord, I have one school.
So until and unless it is discontinued, the scheme is likely to
My lord,
continue.
my lord, it is the implementation of the amendment of the constitution. So I have one school prior to amendment. Now, in lieu of the amendment, the grants come from the central government and the state government enforce it, implement it. Now, the implement this act, the article, the government will include, my school may be robbed in under that scheme. And moment that my school is included, government will grant, extend the grant to me, so that I can implement that. Free
This
and
grant
fair
comes in what form?
compensation.
It's a monetary grant, or it sanctions number of posts for teachers, or
Yes, yes. Now the financial grant they do some instances infrastructural development. So it depends on the requirement of the schools. The school. Now this instant case, earlier three teachers were there, and it was continued. And my lord, after the SSS scheme was introduced, government has limited the sanction of the teachers. The government limited to 3 teachers in the school. One is a Hindi teacher, social studies, and science and mathematics. Now, early this school, 3 teachers were appointed. Private respondent was one of the founding member. He was appointed as a head teacher.
under the scheme,
Before the scheme. Before the scheme.
appointed by the managing committee.
By the managing committee.
State had no role there at that point of time.
But that role also state used to give approval. State used to give approval. It is a recognized.
It means there is to be certain amount of sanction.
My lord. Now it was recognized. The school recognized.
Yeah, see, recognition of school is something different. Recognition of school definitely will not make the government. See, will make this each and every appointment to be approved by the government. Recognition means so far as the academic things of the school is concerned. The government's control over the employee of the school or the service of the teachers comes only when government grants either it's a ad hoc grant in aid, or you say like in aid in any other form. Okay.
Well, this school also right. This school also established and they received the grant before the amendment also. And after amendment, this school was brought under the scheme, SSS scheme. Now therefore, 3 teachers were there, appointment made, approval made, and continued. And thereafter, government limit the strength of the teacher. It reduced to 3 teachers. One is Hindi, one is the language, one is social studies and science and mathematics. Now, one gentleman was appointed as a science teacher, but he resigned. Therefore, in 2014, managing committee resolved and appointed me. I was appointed by I joined the duty
in the place of this person who resigned.
Yeah, resigned.
So
in
you
his
came
place,
entered as a science teacher.
science teacher. I was appointed as science teacher. Managing committee forwarded my appointment to the government for approval. Government took some time. In 2016, granted the provisional approval also.
You were appointed in 2004.
14.
And 2016 they have given
14.
granted provisional.
Well,
Now scheme provides for giving provisional approval.
approval, yes. Approval, yes.
What is the difference between a regular approval and provisional?
Well, they use the term provisional approval. They never issue approval. They use the word provisional approval. That amounts to recognizing the
So that
service.
is the only system under the scheme.
Yes.
That is one system, only one system.
Yes. Right. So after my approval was,
But then by saying provisional approval, what it would mean?
that amounts to my lord government granting recognizing my service under the scheme.
No, that is okay.
Under
but
which
then
I entitled
moment
benefits.
you prefix that word, provisional. So that means there is term stipulation, isn't it? So what is the stipulation?
No, but there is no further terms and condition in the provisional approval.
So it comes.
Yes.
As a matter of practice, it comes as
They
provisional.
use that word, but it amounts to approval,
there
final
are two
approval.
aspects. You see, what we understand, one is provisional approval and another is the final approval. Or
Normally, my
the
lord.
moment you utter that word provisional appointment, that means provisional approval, that means the regular approval will be
Is
dependent
awaited.
on fulfillment of certain conditions.
Yes,
isn't it?
yes, normally.
That is what.
My lord.
That is.
Right.
Anyway.
So government used the word provisional approval in its wisdom, but they never issue final approval. So after my
For
approval,
all the teachers.
yeah, all the teachers. So even the appointment of the private respondent, same thing. Now I continue to teach, and the private respondent number 7, who was appointed as a head teacher, he objected my appointment.
When?
From my initial appointment.
2004.
Yes, 2014. Now
2014.
2014.
You were taken into service in 2014, not 2004.
Yes.
Not 2004.
Well, I'll just refresh the paper.
You said
Yes, 2014. Now I have written letter to the government, and government DC joint director directed for release of the salary. This was never released. Therefore, I filed a writ petition before this honorable court. And during the pendency of the writ petition, the private respondent number 7 approached me to resolve the issue because he was the head teacher, come secretary of the managing committee. So he said that without the secretary of the managing committee, any appointment issued by the managing committee, any provisional approval granted by the government is nullity in nature, because
Can you say that?
That is his claim. So he was then firm with that position. After I filed it, then there was a compromise. The agreement was reached.
There's a compromise.
Compromise between me
you and him.
Yes.
But then there is a government post, isn't it?
Government approval.
But then what effect this compromise would have?
Therefore, I would say that since he's the only one who objected my appointment and approval, so there was an agreement in me and him. And in the agreement, he clearly said that yes, from today onward, I recognize you as a science teacher, and salary would be released accordingly. So on that basis, writ petitioner came and withdraw the writ petition. And thereafter, government has released
Salary will be paid by the government.
Yes.
Undertaking is given by some other person.
Yes, that is true. So those legal consequences are there. So 7 months salary released thereafter. And after that, there was a change of managing committee, and they stopped releasing the salary because the private respondent number 7 again came up with a new managing committee that I was forced to enter to that agreement. I was forced to sign. So it is not my express desire to compromise the matter. It is under duress. Now, he did not file any FIR against me also. And on that basis, new managing committee appointed him as a science teacher.
But then he was already there in service.
He was teacher, head teacher. Now, why he abandoned that head teacher? Because as I submitted earlier, under the SSS scheme, head teacher is no longer a post under the scheme. It stands abolished. Only 3 posts: social studies, science and mathematics, and language teacher.
Yeah, but then one of them, they can function as a head teacher.
Now what happened? Because of the managing committee, it adjusted him from the post of head teacher to language teacher. So he was happy. Subsequently, he changed his mind that I should take over as a science teacher. So he was eyeing for my appointment, against my appointment, to take over my appointment. And he could convince the managing committee, and managing committee passed a resolution, and resolution was forwarded to the STACO. STACO approved his appointment as a science teacher, and I was removed without any issue of show cause notice. 2 approval given in his favor. Now, therefore, this is the crux of the matter, and my contention is that action taken by the managing committee, above all the state, cancelling my approval appointment, is absolutely without fulfilling the procedure requirement. So it is not tenable in law. So may I just take a few annexures? Lordship, kindly come to page 19.
Probably this matter was heard earlier.
How they length earlier? Only the roster change.
Problem is that
was
it's
the-
issue. If matters are not
It was
disposed of,
heard, then it went before my Lord Honorable Chief Justice, my Lord. Then subsequently again it is back here.
It was not heard that he made some queries, so some explanation was there.
any order passed by
Nothing.
No
nothing as
order,
such.
no
Nothing as
effective
such.
order.
Nothing as such. The chief made inquiry, what is the nature of the case, so the party explained. That's all. There was no hearing.
There was there a direction to the respondent number 7 to file an affidavit?
They filed, respondent number 7.
They filed?
Yes.
When they have filed?
That is 2019.
No. There is office note dated 22/4/2024. Chronological list of document has not yet been filed by behalf of the petitioner.
My lord, correct. He used to file something.
Have you seen the office note dated 22/4/2024?
Office note.
Yes,
It says that an affidavit on behalf of the respondent number 7 has not been filed.
Respondent number 7 is Mr. Nat.
My lord,
although all the pleadings are completed,
if I correctly remember, my lord.
No, why this office note is there? Then we have to clarify this office note. Once it is
My
there.
lord, if I correctly remember, my lord, when on the last occasion, my lord, when the matter was taken up before this honorable court, my lord, because there is a lot of annexures, my lord, so there was a direction that everything be set in order, my lord, date-wise.
Those lists we have prepared, and thereafter matter went to Honorable Chief Justice.
No, this seems there is an office note. See, it says that in terms of court's order dated 1/11/2020, an affidavit on behalf of respondent number 7 has not yet been filed. So there is an order on 1/11/2022 asking the respondent number 7 to file an affidavit.
He has.
Now again it says that in terms of the court's order dated 17/8/2023, a chronological list of document has not yet been filed on behalf of the petitioner.
That one we have prepared. And the matter went to Chief Justice courtroom, and the matter came back. That one, if required, my lord, I'll.
But then see, repeatedly the office note is saying that right from February or last December.
We've also not received, my lord, a copy.
Which one?
That chronology.
The list of things I can submit now.
See this, they filed it. When was it filed? But then see the office note.
Yes, file 2.
Last office note.
Yes, file 2. Well, respondent number 7 has filed 2 affidavits. One, a first affidavit he filed on 23rd July 2019, and second affidavit, additional affidavit he filed on 20 April 2021.
But then thereafter, again in 2022, there are office notes.
Thereafter,
it was for the managing committee. And on behalf of managing committee,
number 5, that is the number 25. Respondent number 5, that is managing committee, filed the affidavit on 24th April 2022.
That is so. So, have you filed this chronological list of documents?
My lord, this would be I can submit now if you I'll submit. But that would be relevant, my lord, after we conclude the matter.
Because see, this is reflected in the order dated 17/8/2023 passed by this court. It says, Mr. Sangresh Lani, Senior Counsel, appearing with the petitioner, prays for grant of some time for enabling him to file a chronological list of document with dates.
It is.
Okay. Now that is the opportunity was given. Yes. And office note till date says you have not done it. Now let us then come to this thing. Then what about the affidavit of this one number 7? You must clarify this. You see, this confusion should not remain. So unnecessary things.
Today is 9th. My lord, the office noting for affidavit is when they made the noting. We are not aware that.
Yes.
The date of office noting made by the registry, we don't know when the noting was prepared by the registry, because all the pleadings were completed from 2022.
This is okay, but then see there are orders. It seems there are court order on 1/11/2022.
1/11.
1/11/2022. See the court order is 1/11/2022.
Exchange of breathing.
This is a problem, Mr. Sangresho. If councils do not verify the orders and office notes before matter is taken up for hearing, then it happens. You see, earlier office notes are not pointed out to the court when these orders are passed, and then this more confusion is created.
But if the office noting is for the private respondent number 7, I think he will know he's the right person to clarify.
That is all right, but then whoever is a party, it's their the duty to point out at least to the court. See this order dated on 1/11/2022. R. Devnath, Learned Counsel for the respondent prays for and is allowed as a last chance to file affidavit. Accordingly, this is matter on 14th November 2022.
So you listen, this was for the managing committee. I was appearing.
No, but then for respondent number 7, that is what explicitly this order records. So you have to believe what there in court's order.
For the respondent 7, we filed the 2 affidavit. We are not filing any further affidavit.
When have you filed the affidavit?
One is in dated 22nd July 2019.
Then thereafter, how this order has come to be passed then?
I think earlier what happened, may I explain. He represented for the private respondent number 7.
In response to the order 22/3/2021,
there remains no ambiguity. See, Mr. Sangresho, this is the order. Very clear order, one-line order.
But this one.
See the date of the order.
Perhaps.
And thereafter, this order remained in force. At least this should have been pointed out.
But instead of mentioning respondent number 5, I think perhaps he had submitted respondent number 7.
But the thing should have been corrected. The council should have taken note of this order. Thereafter, repeatedly, office notes were prepared, saying that respondent number 7 has not prepared any affidavit.
Thereafter, he did not file any affidavit after November.
How many respondents are there in the case? Who is appearing for whom? This is a problem. Now, this court will be blamed for, you see, like moving expertise against somebody maybe.
7 respondents are there.
7 respondents are there. Who is the 7th respondent?
1 to 6 are the government. Sorry, 1 to 6, 1 to 4 are the government.
Yes.
5 is the managing committee.
Yes.
6 is the headmaster cum secretary.
Yes.
7 is the school.
Once managing committee is a party, then school is required to be a separate party.
My lord, the school managing committee managed no doubt.
Managing committee is the school itself.
That is true, but
they are inseparable. How can they be separated?
Now, number 7 has filed the affidavit long ago. Number 7 has filed the affidavit long ago.
Now, who is representing 5 and 6?
5 and 6 the same, Mr. Rakhal.
And number 7?
7 myself.
That was for you then to clarify all those things.
7 is the headmaster, my lord, represented by headmaster.
Now, see, 5, 6 and 7 all appears to be respondents connected with the school.
Yes, sir.
Therefore, he represented from the beginning.
That's all right, but then
yes, he has chosen to file only by.
It has been filed on behalf of respondent number 7.
7 only.
So what about 5 and 6?
And thereafter, he came up with an argument allowing him to file an affidavit for managing committee. So court granted, and he filed the affidavit by number 5.
Just let me clarify. When this matter has come up, then I appear on to respondent number 7, because that point of managing committee was not there. So subsequently, managing committee has been appointed. So that point of court asked me, that's when you are representing, then you can represent, take instruction. Then subsequently, after a long time back, then after this I have taken the instruction.
So you should have clarified why not? You should have clarified all those things to the court. Instead, allowed all those office notes to be written in the file.
I didn't go through.
Is it not your duty to check? Are you not the officer of the court?
Sorry, Your Lordship, I didn't check out.
You allow this court to pass, you see, like a wrong order week after week.
I didn't.
This is not the way, you see, like judicial record should be maintained. This is not the way judicial order should be passed. And these courts also, you see, has a blind faith on lawyers. And that is why this is happening. Now, for each and every submission you make, this court will have to turn over the pages to see what is the actual situation, and then they have to take into consideration the submission. This is something very wrong. Now then, Restaurant number 7 has filed an affidavit. Now what will happen to restaurant number 5 and 6?
5 and 6, they also filed the affidavit.
Separate?
They separate they file.
Again they say they are represented by one counsel.
The same counsel.
Is there any difference or contradiction in so far as the affidavit?
My lord, it's more or less the same.
More or less.
It is same.
But even then they have choose to file separate.
Minus.
Okay. Now see, 6 is headmaster come secretary.
Yes.
7 is headmaster.
Headmaster.
Is there any difference between these two persons?
He hold 2 posts, my lord.
One is headmaster come secretary.
Yes.
And another by headmaster.
Yes. So
now
he
then,
must,
just because of 2 posts and 2 separate affidavits is needed.
My lord, therefore he has chosen to file in that way.
No,
and the contention is more or less the same.
Nothing, just this. Basically, you end up confusing the court.
So he has filed. So since the contention is more or less the same, I did not file rejoinder also.
Now, entire thing has ended up. Now, how do you handle that part?
My lord, I may refer to first annexure, page 19. I'll try to.
Before my friend.
Wait. Let us first clarify this affidavit part. 23/7, one affidavit was filed on behalf of respondent number 7. One affidavit by affidavit in opposition on behalf of restaurant number 1, 2, 3, 4.
Yes.
Filed in 2018.
Yes.
Then again an affidavit in opposition on behalf of restaurant number 4.
Yes. Now state also filed 2 affidavits.
So one is for 1, 2, 3, 4. One is for 4 only.
Yes. They could have filed single, but they have chosen in that way.
Going on. Then affidavit on opposition of restaurant number 7.
Yes.
Then comes rejoinder affidavit.
Yes.
There are 2 rejoinder
yes.
against the state.
Yes.
Then another rejoinder against the 7.
Yes.
No, but then there is no affidavit on behalf of restaurant number 6.
Number 6 they did not file.
Number 5 has filed.
Number 5.
See, things become very complicated, and it will be tough for this court to go through all those things and pass an order.
My lord, if the matter is taken up any other date, in the meantime, my lord, we'll also try to serially arrange.
Arrangement means what? You see, like this proper prayer were not made before the court, and not only on one occasion, from many occasions. That is what the problem is. If at all an affidavit on behalf of restaurant number 7 had been filed on 23/7/2019, what is the need of making a prayer before the court on 1/11/2022?
Exactly. Contention.
And thereafter, each and every office note speaks about that restaurant number 7 has not filed any affidavit, and the learned counsels are silent. No one is pointing out.
He could have clarified.
No, that is what the problem is. If you stand up for placing a case, then it becomes your duty to verify these orders and office notes also. This is a mess, like this is something very wrong to happen.
These copies are not available with us also.
What copy?
The copy of the affidavits filed by
That's one number 7.
any of them, my lord. 7, 5, 6, 7. We don't have a copy.
6 has not filed anything. It appears to 7 and 5. So, Mr. Sangreshu, at least one thing is correct, that there appears to be affidavit filed on behalf of restaurant number 1, 2, 3, 4, and then again restaurant number 4,
yes,
then restaurant number 7,
yes,
and then restaurant number 5.
Yes,
Correct?
Correct.
It should not that you see like subsequently some different situation emerges.
Right. That is the exact position.
And so what is to be said with regard to the restaurant number 6? You are representing all three, and you are making more confusion. You make one prayer, you do another thing.
Your Lordship, here, had it been that point of time when they filed the petition, managing committee was there.
You say that, but which way that makes it? You had already filed the affidavit on behalf of restaurant number 7, and subsequently again you sought for time for filing affidavit on behalf of restaurant number 7. What is this? You have not even bothered to open the file also, check the office note also. Repeatedly is reflected the restaurant number 7 has not filed any affidavit. Just say. Our learned counsels appearing to the parties. The office note, the relevant office note indicates that that the affidavit in opposition on behalf of the restaurant number has not yet been filed. 7 has not yet been filed. It is also indicated there. It is also indicated there in that a chronological list of documents which was to be filed with the petitioner, comma, was yet to be filed. Mr. Shangresh, your learned senior counsel, appearing for the petitioner, submits that the chronological list of documents.
A list of dates, my lord. List of dates we have prepared.
Provisional list of
dates. List of dates.
List of
dates.
It says list documents with list.
Well, in the order.
That is what is reflected in the order, in the repeated in the office doodles, and not on one occasion, the many occasions. And that is what the problem is.
We could have checked the order
sheets. At all there is a mistake, if it is detected then and there, or you see like after a few days thereafter could have been corrected.
Correct. That is a mistake on our part. We could have checked that order sheets.
Along with the
documents.
That is what has been said.
Madam, then allow me to
that is what
supply the documents. List is prepared, but allow me to resubmit again.
See, whatever is there in the order, you have to comply with. That is the main thing.
But
if at all you have done also, then or if you say that no separate documents are needed, then we will record it.
But according to me, separate documents are not required. It is already here in the record. But to clarify the chronologically.
If my friend supplies, what will happen is that, my lord, we can rely only on this one. Otherwise, we'll keep on, my lord, once jumping to the affidavit.
No, if these documents are appended chronologically, then why should double documents will unnecessarily confuse us? If documents are already there in the writ petition, let him prepare this thing, the chronological list, along with the date and the page marking in the writ petition. That will help us. Your documents, whatever you refer in your list of dates, will be from the writ petition.
Yes, writ petition.
So you can show the page number also. Then the confusion which Mr. K.P. Bhattacharya is trying to point out would not arise.
In any case, my lord, allow me to prepare with the documents.
Unnecessary, we are entangled with something which basically should not. These are all useless things. Should not have cropped up. Yes, what is the last name? Just say. Chronological. What shall we say? List of documents.
List of documents. Ultimately, dates also will come in the
dates. It's ready.
My lord, list of dates, everything ready now. I've given copy to my friend also.
Yes. What about
now, my friend is insisting for documents as per the records. So I will prepare new one and supply it.
This says chronological list of documents along with dates would be filed within a period of 1 week.
1 week.
That will be enough or not?
Yeah,
just
1 week will be
filed within a period of 1 week. Stop. Mr. R. Devnath, Learned Counsel appearing for the respondent number 5, 6 and 7.
Yes.
Are you sure you are paying
Yes.
5, 6, 7?
Yes.
Submits that an affidavit in opposition on behalf of the respondent had already been filed. And the same is available in the records of this case. He further submits an affidavit in opposition of respondent number 5 has also been filed, and no affidavit in opposition would be filed on behalf of the respondent number 6. Let us clarify this.
That is his submission.
Stop. This submission advanced by the Learned Counsel are taken due note of. Just a submission made by the Learned Counsel. Submission of Mr. R. Devnath has been taken due note of. Taken due note of. It should be not this thing. Due note of. That is what. Instead of saying this thing, submission made the Learned Counsels. Okay. Just a submission made by the note of. Then they give a stop, make a paragraph, list this matter after
1 week.
After a week.
1 week.
These are unnecessary things. But then we have to clarify these office notes and all those things. There may be 1-2 lines addition in this order and all. I'll just check it and then later. It will remain more or less like that, same thing.
9.
Similar method. Connected method.
9 is by another teacher.
By the same party. Same parties.
Why is this subsequent writ petition?
My subsequent petition, my lord, when I filed the first writ petition, there was no termination order. Cancellation of my approval was not there. So after we filed, they filed the counter, and there in the counter, if it is filed by state, they annexed the cancellation order. So subsequent development, I challenge. Subsequently, so it tagged together.
So in the subsequent writ petition also, the
Same
affidavits are to be filed.
They filed the affidavit. But since the contention is
No,
more or less the
whether
same.
same order is required, whether that what is the subsequent? Just see another one. You have to see the order sheet. You see, you cannot just leave it like this. And now you see, like you have basically made this court. There is nothing as such, I think, maybe. These are tagged together.
Tagged together. The same parties.
No, here also the same thing. An affidavit to bring on certain documents has not yet been filed on behalf of the respondent number 7.
Here in the first order, they challenge the resolution.
No, here also the situation remains more or less same. In the office note, it's indicated like that. An affidavit to bring on record certain document has not been filed on behalf of the respondent number 7.
My lord, the respondent number 7 has filed his affidavit on 10 February 2021, as per my record. He has filed on 10 February 2021.
Affidavit in opposition.
Yes, they have filed.
No, but then here it is with pertain to these things. We bring on record certain documents. This is an affidavit bringing on record certain documents.
He made separate prayer after he filed the repetition, counter perhaps.
When this counter was filed?
Counter was filed on 10 February 2021.
This is office note, recent office note, Mr. Sangri.
Perhaps my learned friend has made that prayer. Or whether it is reflected in the order sheet.
This is a mess, mister. This court will not believe your submissions nowadays. It's a very, very difficult situation. When this order was passed to bring on certain documents, this also seems like this office note is there for quite long time. Perhaps you make just prayer just for the avoiding day. Whatever prayer you think fit, you just make to the court. And court believes you, records your submission, and that is why this thing happens. This is office note which is there right from the time before this court was there, Mr. And it's continuing. See here also on the order, this is 13/4/2023. It says on the prayer of Mr. R. Devnath, Learned Counsel for Respondent number 7, as he needs to reconstruct his file, lists his matter on 27/4/2020.
At that time, Your Lordship, I requested because my file was misplaced here.
Mr. Be careful, you see. This is something, you see, you'll lose your credibility before this court. This is something, take serious note.
Your Lordship, that point of time when I make the submission, that time from my chamber, this
was it not your duty to clarify that situation? Why you allow this situation to continue? This court will make an observation that you are making misleading submission before this court. And you challenge it before any other. That is the last option, seems like. It's not something, either it reflects your insincerity or you are doing it intentionally. Well, to find out where is the source of that office note. See, madam, just come. Here, See this office note and see this office note. One is affidavit. Here it is affidavit on being on certain records. These are made on what basis? No, here it's order dated 14 September. It says Mr. R. Devanath, learned counsel for the response number 7, submits that due to unavoidable circumstances, the affidavit could not be filed till date, and he prays that he may be allowed 2 weeks time to file the same. Prayer allowed. Now this is order passed on 14/9/2022.
14/9.
So you
In
received
this,
an
in this
12 October, you received, I filed my affidavit in 12 October 2022.
you filed your affidavit 12 October.
Yes.
10/10 not yet filed.
File by who?
Then next day you ask for adjournment. This is in the header has been filed on behalf of 5 or 7? 5. Not 7. Just please verify. Just check this. No, but then it says you have filed a affidavit on 10/2/2021.
You received on behalf of respondent 7 and respondent 5 later on I filed.
But then your prayer is for with regard to response number 7.
That
The
means
order which has been just now read out.
that is the problem. Without looking the record, he made a prayer. On that basis, court recorded that submission. You could have said that respondent number 6.
This is too much.
That is confusion, I think.
This is too much. That is why office is also confused.
That is
The office has made the entry, affidavit of opposition on behalf of response number 5 has been filed on 14/10/2022, not response number 7. Response number 7 was filed earlier in 2021.
Yes.
But then he has made a prayer.
That is the mistake committed by me.
You need to be careful.
Could have clarified.
It's okay, madam. I think it's all right. It's only. Here, Mr. Sangresho, there are all the things are there.
Yes.
This is filed. This is correct filed. This is 7 is before. Order is 7. He has made a wrong prayer. One wrong prayer makes this entire.
Yes, that is a problem.
Just tell us what is to be done.
He could have clarified.
Tell us, you are professionals. You are not supposed to commit this kind of mistakes.
But I would also request my colleague to look to the noting in the order sheets.
Kindly.
We'll do that. We'll do that.
See, it is not that this mistake has been carried on before this court. It started long back.
Right.
Just see in this order sheet. No, The court is in difficulty now how to, what order to pass. And whom to blame?
Lordship may reflect the purified or whatever mistakes on the part of the legal counsel on that prayer and clarify that order that will serve the purpose.
Okay, just see in this order sheet you say. The office note dated 22/4/2024 reflects 22/4/2024. This is indication number 473. Indicates that no affidavit has been filed. But then here also it said to bring on certain documents. But that is something also indicates that no affidavit has been filed on behalf of the respondent number 7. Mr. R. Devnath, London Council, appearing for the respondent number 5, 6 and 7 submits that an affidavit in opposition on behalf of the respondent number 7 was filed in the matter way back on 10/2/2021. 10/2/2021, which is available in the record. However, it is surprising to note that on 11/10/2022, a prayer was made by Mr. Devnath before this court. No, not 11/10/2022. Just a minute. On 14/9/2022. What you said? However, to allow 2 weeks time for filing an affidavit in opposition of respondent number 7. Stop from the side date. Till today. Several office notes were made in the records of the file to indicate that no affidavit has been filed on behalf of the respondent number 7. It is surprising as to how those office notes were ignored by the office notes were ignored by the London Council for the respondent number 567 all along. It is only upon a query been made from Mr. R. Devnath verified that the prayer was in fact, prayer to grant time was in fact for filing an affidavit on behalf of the respondent number 5 and not respondent number 7. Respondent number 5 and not 7 and just give one and accordingly an affidavit in opposition on behalf of the respondent number 5 has already been filed on 14/10/2022. Stop. It is indeed a sad state of affairs that wrong orders and wrong office notes were made. Only on the ground of what is it? It is in this sad state of affairs to note that several wrong orders and office notes were made on the basis of a wrong submission by the learned counsel. By the learned counsel, by Mr. R. Devnath, learned counsel. It is expected that you should be more careful in making submission before this court in future. Stop. A paragraph on request made by the parties. This matter after a week. No, that one is after.
With the first number.
Sorry, this court has you have left no other option for this court. May not be a very pleasing thing to happen for a lawyer's career, but then something is terrible, and not only in one record, in both records itself. Mr. Sangresha, please communicate and tell your junior colleagues also. We can understand that being senior counsel, you will not be aware of all those things. But then whoever is assisting you, whoever is there with you, kindly tend to be more careful.
Yes.
These are unable things. See, it's not giving benefit to anyone. Okay. But then making the court pass wrong.
Right. It is our duty to assist the court properly.
15.
Hello.